I think now's as good a time as any. Let's get this going. All right, welcome to this session. The second day of talks. Yes, talking is something we can still do. I represent New York City on the board here. Really proud to do that. Thanks again for attending the conference. I would introduce him with all his credentials. This is Nate Ferguson, but he has all his credentials in first slap of his slide. We have vetted everybody for this conference quite scrupulously, thoroughly, scrupulously, with attention to detail, and he's worthy of your time. So thanks for coming. But also, like for the future, if you guys want anything for next year, please be in touch with us throughout the year. We work for you. And without further ado, Nate Ferguson.
Thank you very much. All right, so today we're going to talk about. I had to find kind of a catchy name to make people look at it. Is this too loud, by the way? Yeah. No, we're good. All right, excellent. I had to find a catchy name to call this, so I called it the Cone of Truth. I'm hoping to show you more about what actually happens inside of the yeast cone, inside of your tank. So we're talking mainly today about smarter yeast management for better beer. Now, before we get into the details, who the hell is this guy from Canada talking to you? Some of you I know you, some of you are some of my grads, so this is going to be appropriate. I'm Nate Ferguson. I'm one of the co-founders here of Escarpment Laboratories. My business partner and founder, Angus, is also back there. Two of us here today. We've been around for over 10 years, and outside of Escarpment Labs, I'm also one of the professors at Niagara College for the Brewmaster and Brewery Operations program, where I've been there for just almost 15 years, teaching mainly quality control, quality assurance, sensory, and microbiology. We're kind of in my wheelhouse. I like doing this. So all the things that we do for Escarpment and I do for the college, our main goal, or my main goal, is to help share free, easy-to-access brewery knowledge with you so that you can improve the quality of your beer. Everything we do when it comes to educational content is free, which is why if you go on our website, you go to Escarpment's resources, we have over 80 entries of knowledge base, over 50 hours of free YouTube content on everything from yeast management, best practices, how to make good lagers. We also have, I think we're at episode at least 30 of our podcast now we released earlier this year. We try to release about one of those every single week. They're all free, easy access, try to make things that I find get gatekeeped behind kind of sciences, accessible and easy to understand and digestible for all, because that's a big issue when it comes to the academics. So, my goals today for this, just a quick show of hands, who here repitches yeast cells? Okay, if you did not put your hand up, my goal here is that I hope you get excited to...
Thank you. Test. All right, here we are. Thanks for your patience, everybody. We're going to start with a quick word from the USTA.
Yes, I have just learned so much about yeast. Good morning, everyone. If you don't know me already, I am Rob Gordon. I'm from the United States Tennis Association. If you haven't seen me do my spiel before, and those of you who have like 9 times already, I'll try to throw something different in. So we're the United States Tennis Association. We're the governing body of American tennis. We are the ones who run the U.S. Open every year. And why are we here at a Brewers Conference? What our goal is to help all of your tap rooms fill your slow nights with tennis. Tennis, what are you talking about? How are you going to do that? We have modified equipment. We have slower sponger balls, foam tennis balls that are way slower than the yellow ball. Everyone can play this version of tennis. Is it pickleball? No, it's not pickleball. It's tennis. It's a string racket and a tennis ball, just a very slow tennis ball. A little example. Oh, and also most importantly, we're going to give you everything for free. Our goal is to fill your slow night, and in return, we are growing the sport of tennis. That is our job. We're actually a giant nonprofit, and our profit is people. So the more people playing tennis is better for us. The more people in your bar on a slow Tuesday night is better for you. What else can I tell you? It started, and I'll be super quick, you know the podcast. for quite some time. It started in North Carolina. It was a beer tennis league called Serve Aces. It started with 30 people about 10 years ago. It now has 13 breweries involved and 500 plus players. I'm in my 6th season in Orlando. I have it at one place, and I have between 50 and 85 players a season. It feeds itself. Once you start that first season, it advertises itself because it's really, really super fun. Please visit us at the booth at booth 106 to learn more about it. We can talk more about it, and if you have even a little bit of a space, we can help you make it happen. Thank you very much.
Thanks, Rob. Yeah. Thanks, everybody. Welcome to this session about contract brewing and alternating proprietorships. Our presenter today is Elke Hoffman. I asked her to write me a bio last week, and she didn't. But coincidentally, she happens to be my attorney. She represents our company to the SLA on liquor compliance issues, helps us negotiate leases, and she has a one-person practice that focuses on those sorts of things. Has any number of other clients here at the conference. I don't know if there are any in the room right now. Are you? Yeah, good, perfect. We love working with her, and I bet she is going to surprise and delight us with discussion about hosting other breweries or being a tenant inside. Ladies and gentlemen, Elke Hoffman.
Thank you very much, Jeff. I think I'm going to stay seated because I didn't really want to just have a talk. I kind of wanted to keep it very casual and have a little bit more of a discussion about this issue. And I pitched this back in the fall as a topic because we were starting to get a lot of questions, and we get them sort of from all players in the industry. Some new brands, people just starting out, wanting to create a beer, and they're like, it's an easy way to get into the market. How do I do this? I want to start a brand and just find somebody to do it. And then there's brewers that have excess capacity and are like, oh my gosh, someone wants to come and brew at my space. What do I do? And then existing breweries, right, who are like, wait, I need to make more somewhere. And there's a little bit of confusion about what's required. And so I pitched this panel. And then I didn't really have, I didn't find too many brands that wanted to speak, but I in hindsight, I almost should have renamed the panel, Why Do Brewers Hate Alternating Proprietorships, in light of some of these.
That's my point.
That's a little bit. So I thought I'd like to take advantage of having some people in the room to sort of ask them questions. As a starting point, I'm sure, I don't know how much everybody knows, but from a legal perspective, going back to the difference between, what we mean when we say contract brewing and alternating proprietorships. So the idea of contract brewing, again, very simple. You go to somebody and they make the product for you and they sell it to you, right? It's their, the brewery that's producing it, it's their product, it's their beer, and they sell it to you, and then you sell it to somebody else. The alternating proprietorship is sort of everybody that's there is their own separate little brewery, and they're sharing the equipment, right? And so when you go into an alternating proprietorship, then everybody sort of owns their beer until they sell it to a wholesaler or direct to account. So from like a legal perspective, it's a very different thing. In practice, they can look very similar because everything is sort of governed by your contract, but it can mean different things. And so also for the fun of it, I put the question into AI. I put it into ChatGPT when I was preparing to speak, and I actually got a very elaborate, much more elaborate explanation than I expected. ChatGPT sort of knew more about contract brewing and alternating proprietorships than I expected. But its final conclusion was, if you want to be quick to market, go with contract, and if you want more control, you want alternating. And I thought, well, okay, that's sort of a starting point, but I'm not losing my job yet because it's also not quite accurate, and it doesn't tell the whole story either. And so and I think, you know, one of the nuances is sort of who are you and what are you trying to do? So we used to get a lot of questions from, again, the starting brands that were, you know, I guess 10 years ago, there were a lot of gypsy brewers, right? Just referred to as gypsy brewers. Someone starting a brand, and, you know, 1 week they're brewing at this place, and a couple months later they're brewing here, and they don't have any sort of licenses and any kind of permits. And I think the Liquor Authority came to these conferences too and made pretty clear, like, you can't do that. If you have a brewery, you can't just make beer and sell it to somebody that doesn't have any kind of licenses and permits whatsoever. And so that kind of contract brewing, like, just doesn't exist anymore. You need, even if you're gonna do contract and go, you know, what you think is quick to market, you need some licenses and permits. And that's where you already hit your first sort of, what's wrong with that first assumption, because once you need a license or permit to go to a contract, if you're not already an existing brewery, we'll get to that, you now need to get either a wholesale license or there's a new license type called a brand owner's license. So that means you need an office.
How long is that?
About 3 months.
Okay.
Brand new.
First I've heard it.
Well, and I'll sidebar into why I think it's useless in the beer world. So now you need to become a wholesaler, so you can go to a brewery and have them contract brew your beer, and you are the wholesaler. Under New York State current law, you need an office. So now you need to go rent an office, pay for an office, start your wholesale business so that you can be a brand owner and contract brew with somebody.
Can that office be your residence, like
No.
your home?
No.
No. Okay.
No. The TTB.
Can it be a PO box?
It cannot.
Okay.
You are
It's a
literally
physical
still,
location.
you know, again, you go back to 1934 when these laws were written, records were physical, and the Liquor Authority considers an office a requirement to be able to investigate. And your physical record storage is what's key. So the TTB will allow, even though they know there's not going to be a single piece
It
of
wasn't the
paper
cloud
when
when
they
the
get
law
there.
was written.
Yeah.
Yes, correct. There was not a cloud. But so now you are paying for a wholesale office. If you're upstate, maybe that's not so bad. But if you're in the city, you're paying for an office that you are never in because it's a sort of a fiction, and you can own your brand. The TTB will give a basic permit to a home office, but the Liquor Authority will not.
Oh, okay.
So people say, oh, well, I have the wholesale beer, you know, TTB, but it doesn't really help you in the state.
So is that a licensed premises at the end of the day?
It is a licensed premises, exactly. Even though
So you can't even share it with another.
You can't. Well, as of now, we just submitted a declaratory ruling. You can share it with your own other business if you were imported, but not with another party yet. So if you were like a wine wholesaler and you wanted to do this, you could do this with, you could consolidate commodities, but you can't have two different entities sharing
Can't use
that.
a co-working site.
Could you be a drywall contractor and a beer wholesaler?
Not in the same licensed premises.
Okay.
You can do co-working if it's a space that is designed to be co-working and you have an office with a door, you can do that. It cannot be in the back of like your accountant's office. You can't go through another business.
Right.
But
Because
if
of the
because, you know,
storming in requirement.
because of the
basically.
storming, exactly, because of the storming in requirement. That's why they also won't accept a residence, because you have more rights
Right.
in your home, and so it would be a violation of
Stand your
illegal
ground.
search and seizures.
Stand your ground with the TTB.
Yeah, you stand right, yes. So if you've never done anything before, it could actually take you longer to get this together and cost you more than if you were able to set up an alternating proprietorship with a brewery. Or, you know, a situation that Jeff's encountering too, an out-of-state brewery. That the other thing you lose, in a contract arrangement, if you are not already a licensed brewer, is this idea that you're a brewer, right? And there might be tax credits that come with being a brewer. A lot of, you know, being a wholesaler, there's no tax credits, right? So there may be advantages. And then in New York, you know, if you're a farm brewer, you get 5 branch offices, you can have tap rooms. And, you know, yesterday Commissioner Fan said one of the budget items is to extend that to micro. And so you don't even need to do it as a farm brewer, perhaps, if that passes the budget. So if you are just a wholesaler, you don't have, like, you can't open a tap room, you're running up against Tide House. So, you know, in that case, well, maybe it's worth like doing all the compliance yourself and becoming an alternating proprietorship if you can find someone willing to take you, which might be the next side of the coin. Now, the alternating proprietorship, again, requires a little bit more upfront. You are actually applying to the TTB for a brewer's notice. You're applying to the state for a full, you know, brewer application, you know, license, you know, in a shared facility. And so you are responsible for, you know, if you're going to do colas, you're responsible for colas. You're doing your brand label registration. You're doing your all of your excise taxes. You're doing that all yourself. And actually, so one question I have here is, you know, to ask both Jeff and Devin, who are doing this. You know, I thought from a brewer perspective, you would much rather have alternating proprietorships because it takes all of the. I was actually really surprised. I'm like, wait, wouldn't you rather push that off to the brand to deal with themselves?
You have brewers as clients, right? How good are they about getting you things timely?
You're excellent, Jeff.
You are excellent.
Right,
How
right.
good is your client base?
It can be very hard to manage a production schedule for a cola that hasn't been approved yet.
And you find that doing it just as contract, you can eliminate some of
It's
those
an imaginary
bottlenecks.
scenario,
It's-
but
It's very hard to
easy
manage a
imagine.
it's very hard to manage a production schedule.
Yeah.
Period. Then when you bring another party in, it just seems, at least for me, seems to really overcomplicate the matter. You know, the schedule needs to be the schedule needs to be the schedule.
And when we've negotiated contracts around this, at times you have to certify that you're going to treat everyone equally
Yep.
inside your four walls, which is very challenging to do. Gives that tenant a lot of standing.
Okay.
At your brewery.
At your brewery. Right, and if you have multiple of those, then you're really
They
juggling.
can be at odds, their needs can be at odds with each other.
Interesting. So one other question I had too, you know, talking about the logistics and are they getting you things timely? When you, do you lose the economies of scale when you're doing it? You know, I thought, you know, when you're doing an alternate proprietorship, like I would think that in contract too, you can buy more things in bulk. And maybe give, you know, it costs the brand less and it costs you less because you're buying malt in.
I don't think so.
Yeah, my experience has been operationally, it's about the same. You're already sharing, let's say, malt and
Silo
cans.
malls. Yep.
And
You're buying your
some extent-
pressure
some
sensitive
extent
labels
costs,
in
yeah.
larger quantities for everybody, so it's driving everyone's costs down.
Yeah.
So there is some.
So there's not necessarily a benefit to an AP on the purchasing side, because you can do that anyway. There's no constraints around that. But I understand why. Is anyone in the room a brand that is operating inside another brewery or buying beer from someone? What's your scenario?
We were wholesaling and switched over to all prop.
Okay.
Oh, cool.
So we were contract brewing and now it's all prop work, and they just switched over.
And what drove the switch?
I mean, we wanted the flexibility, like Alex said, of having our own space in the future, and obviously under the wholesale thing, we wouldn't be able to do that. So just thinking of future growth and long term, it made sense to switch.
And was your host receptive to the move?
Yeah,
And do they do both, or do they tend toward one?
they do both.
Very interesting.
Yeah.
So on the other side of that, so we host an alternating proprietorship, as well as two contract partners. One is a smaller brewery and one is has a wholesale license. So I am hosting 3 different relationships. Yeah. And for the alternating proprietorship, it works out really well with me, but I adore the guys on the other side of the deal, and they did the alternating proprietorship because they're a brewery in planning that is waiting to build a space, and so that made more sense for them to apply for their brewer's license from the state.
And can I ask you both, in practice, are those brewers coming in and are active in the production and are sort of philosophically
They're brewers in your
living
space.
in the spirit of the
Yeah, so with that person, anytime you grow on a new system, it's like, it's a learning curve. So, that particular person had 15, 20 years in the industry, but still like learning a new
System.
vehicle.
So do they come in and operate your brewery?
So the first day I did everything, talked him through my process.
Yeah.
Trained him.
And then the second day, I talked him through the process where, he did everything, and then by now, I think he's brewing tomorrow, and I'm gonna train right back. And so I basically trained him how to run our brewery, and now he has a key, he does his own thing. So, it works out really well for me too, because I'm understaffed right now, so it helps me fill this in without having to hire somebody.
Has anything
Empty
ever
tanks don't make money.
has anything ever gone wrong?
Um,
Burned out motor or something like that?
Not yet.
Yeah. Have you gamed out those scenarios?
Not yet.
Yeah, we talked about it, and sorry, this isn't like super fresh in my mind, but
Yeah.
we wrote everything down beforehand in a contract. We actually both worked with the same lawyer, and she wrote down, made sure that what we wrote made sense.
Is that good or bad?
That was my
I-
Same way.
Well,
That's a great question.
yeah, I mean, I think, there's always a conflict of interest, and there's not that many of us in this industry, so I think, we often end up having two clients that get involved with transactions for each other. I personally get.
client, don't we?
Yeah, but I get a little bit uncomfortable with being on both sides of the same transactional deal. I feel like, with licensing and permits, you can sort of push it, and I don't know that I would be comfortable representing both the host and tenant in some of these. I'd have to think about whether with like a waiver I could
Is
do
there something
that.
inherently adversarial?
I mean, there's always, like who's taking the liability and the risk of loss,
Does he carry insurance in your? Yeah.
Yeah.
And for sure, like,
Or they rather say.
it's cooperative, and I think it's like, it can be absolutely be a win-win scenario until something goes wrong.
Until something goes
Yeah,
wrong.
yeah.
I have a question just about on the AP side. Is there any requirement written into the law that the tenant brewer has to actually physically brew the beer, or can they simply just give you a recipe, write you a check, and you go from milling in to packaging in a can, putting it on a truck?
I mean, you can get pretty close to that in the agreement. There is a requirement that that the brewer has control, like, so they're supposed to have control, but they can hire your people to do pretty much everything, right? And they need to theoretically have they need a space for records when they submit their brewer's notice application. They have to be able to keep the records. They are, in theory, in charge. It can be very easily drafted into an agreement that they have the right to have a representative there. They have the right to be there. Whether they actually show up, no. But I think, one of my points is here. These agreements, the actual arrangement can be really similar, other than the back end legal. What you do in your contract brewing, we've also seen contract brewing arrangements where someone has the right to be there the whole time and supervise because it's contract on paper and they're not doing the compliance, but they also really want to be on site.
That's in our agreement. Our contract clients have the right to have a company representative on site anytime their beer is in the brew house or in any tanks or running through the packaging line.
And so I think in practice, like, someone needs to, or on paper, someone needs to be there and needs to have control, but can they hire your people to pretty much do, like, soup to, yeah, they can.
Which is also less of a payroll requirement.
Yeah, And so I one of the other points I'm the lawyer, so I like to over-document, all of this, but, your agreements can go point by point, and on every single topic, a contract brewing arrangement can look a lot like an alternative proprietorship agreement. And I think you really need to talk about, who's buying the ingredients? You know, what happened if there's a schedule under either scenario? If there's specialty ingredients that the brand is getting themselves, like how much, you know, how much? When do they need to be there? Can they show up the day before? Do they really need to be there? Are you going to share?
That's a great example of the COLA scenario. Waiting on an ingredient from this.
And then, you know, who's on the hook if you had a deadline, a wholesaler
That's a real
order? Yeah. And then who's on the hook? Do you get to charge more for doing it, or are you?
You get to charge like a
And
tank
who's
delay
responsible
fee
for
or
the-
something.
Who's responsible for the quality of a product made with an ingredient unknown to me?
Right. Do you have the right to approve specialty ingredients? I know you're.
But that
you're a
also
contract-
runs into like we do only contract brewing agreements. We don't do all props at Paradox, but we do have clients who use ingredients that we definitely don't use in our beers, and we have actually run into that issue where they're like, well, it's not behaving like it does at our brewery, and we're like, well. It's a weird beer.
Right.
I don't know what to tell you. You know, if it's going to run different at your place than it does at ours.
Well, or these hops are from 2021.
Right, and if you want your product to come out like it does at your brewery, then you're gonna have to send us your ingredients because we're doing our best to source, but this is not stuff we're experts in. So I guess my point is like it's still very much a transactional relationship or like a collab kind of.
Yeah,
For lack of a better term, even with contract with alternating proprietorship, you know, you have to make that beer run at your brewery.
Sure, and I think your scenario is a little different where you're close with this person and there's a level of trust. And I don't think
That's awesome.
Not every relationship is like that, of course.
So how do you deal? And I know you do this a little bit differently, but you know, the forecasting so that you can do the. You know, I know we put into our contracts a lot of things like rolling forecasts, where here's what you estimate in 180 days, and then it becomes binding for 6 days. How you know, are you able to manage that?
Yeah, we require a PO 30 days before production, so we can effectively schedule it. But that's a function of what our production flexibility is. Somebody might be able to do that with a week's notice, and somebody might need 90 days. But 30 days works for us.
We do the same, but 28 days. Jeff gives you 2 more days. Than I do.
But now also in your additional.
But in practice, the hops show up when we're mashing in.
Right, exactly.
Sorry.
No, like so. Now, Debbie, you guys are also doing again sort of a model where you're offering some more involved services, and that I imagine now you're also sort of involved in estimating what the volumes are yourself, which is like
it's getting pretty complicated. To be totally honest with you. We are. We're offering
like a
shared sales
variation.
representative services and strategic partnerships now. So when we kind of engage in the strategic partnership lane, we're forecasting, we're trying to read the tea leaves, we're looking at old data to try to figure out what needs to happen while we're actively like changing the sales of the company. So yeah, it's tough.
But you have a little bit more control again,
Yes, quite a bit more.
because you're not just then dealing with like purchase orders that they come in. Now, what happens? Have you hit a scenario where, like, everyone, you know, you have same deadlines and you're at capacity for particular, and you do have to sort of pick or choose, or that hasn't happened?
Well, ideally, you haven't oversold your capacity, right?
But it's there's the overall capacity and the, oh my gosh, we have a deadline. It's you know, St. Patrick's Day is coming up, and everyone's trying to do green beer.
Everybody's got priorities, right, at any given time, but I'm kind of running over you, Jeff, but
No, not at all.
when we start looking at the capacity wall, we buy tanks from Jeff.
So I think there are, you know, some other things that also, you know, when we think about what goes into like the alternating proprietorship, agreement. Well, I guess either one too. I mean, in an alternating proprietorship, it's pretty clear that the brand is doing the colas and doing all of the paperwork. But now when you have like a brewery that has a couple of locations, you know, you're also worrying about like trying to get the labels right, so you don't have, you know, so you can give the impression that you are still the brewer there. You know, in an alternating proprietorship, you're very clear that you're on the label as the brewer. In the contract brewing scenario, you know, when you give the city, people might know, well, gee, that's, you know,
That's not where that brewery
that's
is.
Saratoga Springs. Like that's not where your brewery is. And you can file for, you know, with the TTB to get the trade label so that it looks sort of seamless.
What is that called? Assumed name?
Yeah, you find the assumed name and like a bottling trade name that you
That's
file
how we do it.
with
So the client name can go on, but
Can-
it still
can-
has our
But it has
town.
It has your town, and so that looks a little bit different. If there is an existing brewery, maybe you can get away with putting both towns on there so that it looks a little bit more like you have.
I have clients that do
We've had
both.
trouble with that with the contract.
Have you?
Yeah.
I have one client that does
That has
the
both?
same. Yep.
That is
North
two-
Hudson and blah blah blah.
Yeah.
Yeah, I think the TTB
It
will
depends
also
on the
be
examiner.
examiner.
But,
Yeah, it's a little bit
Everything
inconsistent.
depends on the examiner.
Yeah.
Now that
And
battle's
especially
gone.
if the customer has a geographical location in their name.
We've ran into big issues with that.
Interesting.
With customers, contract
From
clients.
a SLA brand label registration or is it
TTB. From TTB, yep. They've told us you can't put that area on that can because it's not made in that area. We literally had to strip out, or we had a contract client who needed to strip out like their place name
Yeah,
from
and
their logo
Just from
to run with us.
a capricious examiner, you know.
Yep. Yes, exactly.
And now
I should have probably just rejected the colas and just refiled like a week later.
Yeah.
So I saw what I got.
Yeah, see if you get
And
something.
so something like that, obviously you wouldn't have that issue if it were an alternating proprietor. Is there a scenario in which you would entertain an alternating proprietorship?
No.
Okay, fair.
It's an employee management issue for me, to be totally honest with you. Who works for whom? You know, I have to trust somebody else to manage another employee in our four walls. That's what it comes down to for me.
But not, you know,
Yeah.
but again, it doesn't really have to be that way, right? You know,
I learned that today, though.
I'm also
Yeah,
playing devil's advocate
but
because there's
that-
not a
that's
brand
the-
owner and a pro.
That's probably the real material question is, you can operate it however you agree to operate it.
Right. What if you break something?
What if you break something?
Who's mad at
Well, You
who,
have to
right?
need a robust
Right.
agreement between the two parties.
Which I think it works for you, because friendly relationship, right?
Yeah, I think so far so good. You know, it's gone great so far. Yeah.
Yeah, you know, I was a little bit
That's why
surprised.
it works, though.
I think it really just depends on like the dynamic between the people and you know the better that dynamic is, maybe the less you have to go back to the contract. But
Yeah.
my strategy going into it is like we're gonna write down everything and deal with all.
We're never gonna look at this again,
scenarios,
'cause it's
and
gonna be cool.
Hopefully, we never look at it.
Right.
And we haven't had to so far, so hopefully we can.
Yeah, to me, you know, I was a little bit surprised to hear this because I also would have thought that, you know, the risks of compliance and liability and taxes and perhaps hitting the capacity where you're paying higher taxes because you're producing more.
Yeah.
that
Good problems to
that a
have,
facility might be like actually, you know, because you don't actually have to turn it over to control and you don't have to do that. It would have been that my as a lawyer, my thought was like, oh my gosh, it must be so much easier for a brewery to just allow an alt proprietorship and not worry about excise taxes and compliance and, you know, pickups to wholesalers and so I was a little bit surprised that sort of the trade-off is like we're doing that anyway. We might as well keep doing it. We're set up to do it and, you know, have control.
That's a key word right there.
Control.
There you go.
Control. Yeah.
So
You gotta stand up first.
Who's accountable in an AP scenario
who's accountable to ag and markets during an inspection? Let's say your friend's brewing, your big brewing, you're not there, ag and markets walks in, you know, who's accountable to them for whatever thing they may find at that time?
Usually in the contract, the facility itself, you know, the division of like liability, if it's, because we refer, the host is usually responsible for like the facility related things, right? If you know, you don't have the right number of drains, or, you know, the refrigerator's not cold enough, that's usually on the host, you know. Someone's maintaining it, especially if it's the kind of host where you might have a couple of different, you know, businesses. Like the agreement would put, and this is a good point too, you know, the liability provisions of the agreement and sort of the product liability, you very clearly push back to the brand and the host. Like, it's your ingredients, if your product makes somebody sick, it's on you. I mean, the physical space and the insurance for the physical space is usually still the host. They're the ones that have the lease. You know, it's their facility. They're usually managing, and part of your fee is things like, you know, trash disposal and all that. They're not getting, you know, you're not getting 5 different exterminators in there either. Like the physical space, and part of what you're paying for is like the maintenance of the physical space.
You know, thinking of a scenario like, say, your friend comes in, he brings in a pallet of malt, and it's sitting outside of his place, and there's rat feces on it and things like that, you know, and the inspector will through. You know, so how do you know, you're not responsible for that, right? I mean, that shouldn't be borne to you, but, you know.
Yeah, it'll be in your agreement, because Ag Markets is going to hold the facility liable. If there's like, if there's a fine from Ag Markets or your local health department, like, they're, you know, they don't know who the, you know, your tenants are. So between you and the agreement, you've got to say, if, you know, if we're fined for something that is your fault, if you damage our equipment, you know, these are things that in your contract you're going to make sure that you're, you know, that the tenant brewer, you know, indemnifies you for, reimburses your costs, you know, et cetera.
Like, we require customers to meet all of our preferred supplier protocols. So like, you can't send in ingredients from a supplier we've never heard of and seen any of their you know, COAs. Like, we need COAs on anything that you're sending into our brewery, so you can again maintain control of scenarios like that. Like, and again, it's about defining that ahead of time, that, you know, if you are going to make beer here with your ingredients, these ingredients need to be of a certain standard.
We actively try to push our clients away from buying their own ingredients. Our whole model is like,
Sure.
let's all buy together. Let's drive everyone's
They all
costs.
have extra hops right now.
They all have extra. Yeah, yes, they do. Yeah, that's it. But that's fine. You know what? Extra hops on your YCH contract will help you with that.
YCH
no problem.
Is already a
Right, exactly. Okay, so
supplier
good point.
of us,
Yes,
right?
yes, very good
As
point.
long as we understand the provenance of the ingredients, we can.
Yeah, we would do the same thing. We haven't really run into that situation. Our kind of model is we do everything for you, so you don't have to.
Right.
But you know, if we did, yeah, sure.
You could work
Send your contract from YCH.
You
No
could
problem.
work a rat feces clause in there.
Yeah, if that's what you want in your
Refer to
beer.
it as that, yeah, no. I mean, again, similar with like, right, damaging equipment, you know, breaking, leaving, you know, and yeah, and you're going to be responsible for your own actions, but the host generally will end up being on the hook for the facility.
Just seems like a huge risk.
Elkie and I were talking to another brewer last night about co-packing customers coming in, especially maybe 10 or more years ago, and saying, hey, I want to brew my Gypsy brand here. And there's a certain amount of pride that a brewer has in the place they've built and the investment they've made. And someone wanting to come in and hold a license and enjoy some of the benefits that come along with that hard work is
Tough.
a barrier.
Interesting.
It is for me too.
Yeah, like a
And
message
especially-
to
Good point.
share your facility and this is your
As
base,
if
this is
it's
your
built.
base.
As if it were theirs.
Right.
Because it
There's
is
a
on
there's a
paper.
hurdle there. It's not insurmountable. But the scenario I have today is a potential customer who's from out of state but wants to hold a farm brewing license in New York State and is adamant that it shouldn't bother me.
Right.
But there is no
Said
scenario
client has
where-
asked me why Jeff is so adamant in his
this person asked
policies.
you this, yeah.
But
So,
it's
you
a
know, it's-
significant consideration, right,
Yeah.
for someone who is just starting a brand or is out of state. The benefits of being able to be your own farm brewer if you
Your
don't.
own wholesaler.
Oh, but to have branch offices and tap rooms, this world open is a very different proposition, right?
Yes.
And so I can.
And I struggle philosophically with that, with facilitating that. Because it's at the expense of our, honestly,
Right.
of our membership,
You'd have to charge,
right? Of this group's membership.
because
They
it
become
feels like
they
it's not
become
a
a competitor.
a competitor that's
yeah.
not, that didn't invest in the process.
Yeah. And that's I think that's my main issue with APAs.
And so if somebody came to you and they were starting a brand, I mean, you probably can't even do the small volumes. Does it feel different if that person is local and starting a craft brand in New York? Again, like a
Oh,
common
sure.
scenario is
Absolutely.
like the one described where like, hey, look, we're doing this while we're building our facility, and therefore, does that
We
feel
generally won't
different?
engage if you're just starting a brand
Sure.
because it's too risky.
Probably
these-
the volumes are not enough.
the volumes are not enough. Not to disparage anybody, but if you're just starting a brand and that's all you got going and you've not really been in the beer business, are you going to be able to sell 30 barrels of beer? We've run into that. We've taken on those
Are you going to be able to pay me?
Well, yeah, more importantly, right? Yes, but it's all conflated, right? And we've run into that scenario before. We've taken on some clients who just wanted to start a brand, and it's never really worked out well. You got to have some skin in the game.
Yes, in the back.
I want to go down that rabbit hole a little bit. If you got an outside, non-New York State brewery that was trying to get established in another state, trying to get a New York State microbrewer's license, they contract brew with somebody, whatever, five batches a year. Can they bring their out-of-state beer and sell it in a tap room in New York State and kind of end around?
It'd have to go through a
bunch of
wholesaler,
stuff?
probably.
Through wholesale, if you had an on-premise license that allowed for that.
I mean, again, that's the big distinction. As a contract brewer, if you're just an out-of-state licensed brewer, you don't have the right to like open a tap room or do self-distribution in New York State. If you're really a Connecticut brewery and you're filling your capacity, you can't just automatically self-distribute. You don't exist in New York State, right? As the alternating proprietorship, you then are a bona fide brewer, and you could open a branch office, and at that branch office, you could open a bar or a restaurant. You have all the self-distribution rights that you would have. Your out-of-state brewery would otherwise have to, the beer can go out of state. That's fine. But you don't automatically have the right to sell direct to a bar or restaurant. You're going back into, your brewery selling back to a wholesaler, through that 3-tier system and to the retailers. If it's just a straight, contract relationship. We touched about a little bit this new brand owner's license that was just implemented. The legislature and the state liquor authority pushed through. There is a new license type called a brand owner's license. I don't think that anyone in the beer industry will ever use it. I think a little bit of the pressure came from companies doing ready-to-drink cocktails that wanted to own that wanted to do, and after COVID, everyone wanted to do RTDs, and so you could. And there was no mechanism for someone that has a brand to go to a distiller and make a product, again, similar with beer. And it allows somebody to go to a producer and allow contract manufacturing, and then the product has to be sold to a wholesaler. And so I think in the beer world, it might, and so if you are doing a ready-to-drink cocktail, you can do this and then sell to one of the wholesalers that's allowed to do this. I think in the beer world, it's tough because that means you, as your startup brand, have to go to a wholesaler. You're not allowed to sell direct to consumers. So you still have the office requirement that the SLA is imposing on all of these licenses. As a brand owner, they're imposing the same office requirement, and now you have to find a wholesaler to pick up your product. And because you're subject to franchise laws, you are now tied to that wholesaler. So you're starting out your brand, you're just a brand owner, you can't sell directly to the accounts, and if you're lucky enough to get a wholesaler to pick you up in the first place, you now have to pay him if you ever want to get out of your contract. So I don't see a scenario in which any beer brand owner would get the brand owner's license and not just check the box to be a wholesaler directly. And you could still choose to sell to a wholesaler if you wanted to, but you can also, quote,
Be
get
the
closer
wholesaler.
you could get closer to what looks like self-distribution, right? If you were just a wholesaler, right? You can be the wholesaler and have your sales team run around to, to accounts and sell directly to bars and restaurants, as opposed to hoping that a wholesaler will, rep your brand new product, which I think is a tough sell. So I don't see the new brand owner's license helping the craft beer industry too much.
Can anybody much?
Yeah.
Could you just like comment on your experience of like how much do you see differentiation between like one contract, just wants to pick up the beer when it's done, and like maybe another contract wants to be involved on the day to day? Like, do you see a lot of variability between people that way?
I see it change over the course of the relationship, really. It starts out where people are very invested and really trying to come in and observe things and see what's going on. And then as the trust is built, they kind of come around less and less. And then it kind of devolves into, we're just sending you invoices and we're shipping out your beer. I don't know about your experience.
No, I mean, every relationship is a little different, and I've had that experience and also completely hands off, right? From the beginning.
Oh yeah, we have a couple of those. Those are easy.
Do you think there's much perception in the market that's different for whether someone's doing like contract or, from a pure marketing perspective?
I think there used to be, but not anymore.
Yeah, I think less so, and the assumed name workaround gets you 90% over that.
Yeah.
That you don't have to use the
Brewed by.
host's name on the label.
I agree with that. We had a question over here.
Yeah, sure. So you don't want to think about it when you're starting the relationship, but it's always good to have a view to having it stop and having it end.
Yep.
And it's probably better to do that at the beginning, just in case. Any thoughts on best practices to have built in orderly transition clauses or other sorts of mechanisms to conclude the relationship when the time's contract?
We got it in our contract. I think it's 60 days notice or something like that. Like, give us notice, and as long as you've met your volume requirements for that year, no problemo. But just give us advance notice.
Yeah, and I think we usually start at maybe we want to give 30 days, and
Yeah.
we'll negotiate it longer. We start with something that's more in our favor.
Yep.
And obviously,
But yeah, that's and great point, Tim. Every one of these relationships is going to end one day.
Yeah.
yeah.
Honestly, we kind of hope they do. We hope we get people's volumes up and they build a brewery.
Yeah, I
That's
mean,
what we're looking for.
as the lawyer, term and termination always, comes up. And is there like a fixed term first? Sometimes they're like a 1 year
Right, is it 1 year
ramp
that
up.
renews?
We have a 1 year that renews. And
So
basically by September 5th every year, you got to let us know what you want to do for the next year.
And then making sure, right, any specialty ingredients and packaging, that gets sort of settled. If you're doing contract and someone has purchased labels and printed them, you're reimbursing them for any of those outright expenses too. Or if they've purchased specialty ingredients at your request, obviously you're going to be on the hook for that. So, but and just thinking that through in the beginning, and literally for both of your businesses, how much notice do you need? And if you know from the beginning that you're doing this temporarily while you're building a facility, it's a little bit easier to plan for it.
Same question, but now you're the person, you're not the host. So there's know-how that the host might have, there's inventory the host may have. Just wonder if the answer changes at all if you're looking at the other.
It's interesting because I've been on the other side of it too.
Yeah.
At a host that required that you do an alternating proprietorship. And they just had a different model where they would invoice at every step. Like, you make work, you get an invoice. You dry hop, you get an invoice.
It sounds like an accounting nightmare.
I think it gave them a really clean Like, we were
Right, we've been paid
much
for the
more,
work.
we were operating inside their brewery.
Right.
We could leave anytime we wanted. We could let our license lapse. We had to maintain our license. We had to jump through all those hoops, and it happened to be out of state. It was a whole other, like, there was a whole other thing we had to unwind by becoming we became a business out of state, and there's some unexpected unknown unknowns that happen when you do that. Yeah, you want definition around how to get out of it.
And I think this is
But
one
we
good
want that too.
Yeah.
I
one
want to
good
know.
example though of why you might not want to just go with a standard contract too.
Mm-hmm.
You know, if you're a brewery and you are looking just for some places to do excess, maybe you don't need as much lead time because you can go elsewhere. If you're a brand starting out and you are fully relying on this one person, maybe you want more than 60 days for them to kick you out. Like if you know, in a small scenario too, if suddenly your brand takes off and you don't have enough capacity for this contract person, you give them 60 days notice and they don't have any place else to go, like then you're in.
Yeah, they'll be out of stock.
Right, you're done. So, as many, you know, even these guys, you might have standard contracts, but if you're representing like the tenant or the brand, you know, don't just sign the standard contract that one is, you know, like look, you know, this is why we're still in business as lawyers too. You know, here's your standard contract, but the standard 60 days might not make sense for you, or you might need more. Huh?
The lawyer would say, don't sign the standard contract.
Don't sign a standard contract. Please have a contract and don't, you know, read through it and think, hey, wait, I'm not sure I can give these forecasts, or wait, I'm not sure I can meet these deadlines. I need more notice, or you know, I need to protect. Yeah.
Can you comment on the legality of putting 55C type requirements on a customer in a contract, such as if we make 100,000 cases for you in calendar year 25 and you terminate that agreement through the termination clause that's legal within our contract, that's fine, but you owe me $2 a case.
We're just trying. We're trying something very similar in an agreement now. Exactly, building in. You're not obviously subject to 55C. I'm not sure if everybody knows. Right? It's
Everybody knows it though.
Everybody
55C.
everybody knows 55C. All right. But this idea that a termination might come with a fee, it's negotiable, right? And so we're putting it into one of the paradigms.
I mean,
They always push back, but you just negotiate it.
a minimum over a period might effectively do that too. Lock them into purchasing a minimum, and if they don't, there's a penalty, right?
I find that,
I think a lot of
I mean,
I think
you
a
still
lot
have to collect,
contract-
on the penalty.
Exactly,
Yeah.
that's my point, they can still, you know, it's one way, but if they do leave and they say, I'm gonna go to the brewery down the street, if they gave me, you know,
A better deal.
that price, no problem.
Right.
And you don't.
Yeah, I mean, you could also see, I mean, we even do this in distribution agreements. If you're leaving and because now you're taking it in-house, it's a different scenario than if you're leaving maybe to go to a competitor, right? You know, so when we negotiate even distribution agreements, you know, we might have a different termination fee if someone's not going to shift. If you're small and you're now just going to take it all in-house, you know, maybe what the termination fee is a different volume than if you're now switching up to another one. But it might make sense depending on how much, you know, did you have to buy specialty equipment? Did you have to did you have to turn down other clients to keep this one on there, and then you're stuck, you know?
But there's no legal, there's nothing legally blocking that. It's
No.
under law.
No. I mean, again, you're not automatically protected under the law. 55C is this weird provision that says, you know, no matter what a contract says, you're going to have to do this. But you can contract, you know, if there's leverage and, you know, yeah. If you have a big player and you're concerned that they're just going to jump ship because they're going to get a slightly better deal,
Protect yourself.
protect yourself, yeah.
We've got just a couple more minutes. Is there any high points that you needed to hit?
No, I think from the lawyer perspective, my point is like go through the contract and actually think about the logistics too, and make the contract match what you're looking to do. And an alternating proprietorship and the contract can look very similar in practice with a few exceptions and obviously the back end and the filings. And don't rely on AI just to tell you which to be, but there could be a scenario in which you're actually faster to market as an alternating proprietorship because you can get a farm brewer's notice or get the TTB farm brewers and farm brewer license and a manufacturing temporary permit now, and you're up and running as your own brewery faster than if you had to lease an office as a wholesaler. And look through the contract and think and revisit your contract. We were talking about this too. When you start a relationship, this is what you think it might be, and as you get into it, it might change. Like you say, people maybe insisted on lots of control, and then maybe they don't want it and they want to be more hands off. Revisit it every so often and see what makes sense.
Any other questions? Yeah.
Can you explain more about the assumed name on the can? Is that something that's held through the registration process?
It's a TTB thing.
TTB has a process, you go to the main entity and you can apply to add another trade name as a bottling trade name or labeling trade name. And so with that, then, you can pick, if you're working with a contract brand, you add their trade name. We used to file all the certificates of assumed name with New York State. We don't always anymore. The TTB stopped asking for proofs of certificates of assumed name.
I don't do that.
Yeah, and all we do is file and never even confirm it.
I file it with the TTB and I get an instantaneous email back. They're like, "Yep, cool."
We get them. we get yours.
Someone gets an email.
But you don't even need a release on the IP or anything.
No, they don't ask for anything anymore.
What we do is I have a form letter that I send to our clients. I'm like, put this on your company letterhead, sign it, send it back to me so I can file it with the TTB, and then I'm not even joking, it comes back
it's
instantaneously.
And so they can. So when you go and get your cola, if you need a cola,
Colas don't come back instantaneously.
They don't come back instantaneously, but it can look. It literally has that trade name. It's brewed by so-and-so, and you don't need. Have you ever had to put the under special arrangement by language? Has the TTB required you to use that either? No.
Likewise.
I know Jessica told me she did, but we have not either. So
Never
it doesn't
run into
even,
that.
there's nothing that would sort of even let a consumer know, other than if they know the location of the breweries, that it's actually, contract brewed and not, a facility.
Anything else? Well, thanks for joining us. Thanks, Elke.
Thank you.
And I'm sorry, I didn't introduce Devin Hamilton. Devin Hamilton, everyone.
Thank you, Jeff. That was very nice of you.